The morning Deborah Patterson from the HOA left that bright orange violation notice taped to my front door was the same morning I realized just how petty suburban warfare could get. I had lived in Meadowbrook Estates in Henderson, Nevada, for 3 years without incident, keeping my lawn trimmed to the exact 2.5 inches specified in the community guidelines, painting my house only approved colors, and generally minding my own business. But apparently, storing two 20-pound propane tanks on the side of my house behind a lattice screen was a bridge too far for Deborah and her merry band of rule enforcers. I stood there in my driveway at 7 in the morning, still in my pajama pants, reading the notice with increasing disbelief. The fine was $250, with an additional $50 per day if the violation was not corrected within 72 hours. My name, Henry Lawson, was printed at the top in bold letters like I was some kind of criminal. The violation cited Section 12.4 of the Community Covenants, which apparently prohibited the storage of flammable materials visible from any public space or neighboring property. The thing was, those propane tanks were not even visible from the street. I had specifically built a decorative lattice screen painted in HOA-approved desert tan to keep them hidden. They powered my backup generator and my outdoor grill, both of which were perfectly normal things for a homeowner to have. I had checked the covenants before installing them. Nowhere did it say anything about propane tanks behind approved screening. I crumpled the notice in my fist and looked across the street. Deborah's house sat there like a monument to suburban conformity, her perfectly manicured lawn gleaming with fresh sprinkler water, despite the drought restrictions everyone else was supposed to follow. Her silver Lexus was parked in the driveway at a perfect angle, and I could see her standing in her front window, coffee mug in hand, watching me. When our eyes met, she did not look away. She just took a sip of her coffee with this satisfied expression that made my blood boil. I went inside and called my lawyer buddy Marcus, who lived 2 towns over. He answered on the 3rd ring, sounding groggy. "Henry, it's 7 in the morning on a Saturday. Someone better be dead. Deborah Patterson just fined me for my propane tanks. The HOA lady. The one you said looks like she eats kittens for breakfast. That's the one. $250, Marcus, plus $50 a day if I do not move them." I heard him sit up, suddenly more alert. "Wait, the tank's behind that screen you built, the one you showed me pictures of. Those are not visible from anywhere." "I know. That's what I am saying. She is making this up." Marcus was quiet for a moment, and I could hear papers rustling in the background. "Send me a picture of the violation notice and your property. Also send me the section of the covenants she cited." "I will look at it, but Henry, HOAs are tricky. They have a lot of power even when they are wrong." "So what am I supposed to do? Just pay the fine and move my tanks?" "Let me look at the documents first. Do not do anything until we talk later today. And definitely do not confront Deborah." These HOA board members live for confrontation. It's like fuel for them. I promised I would wait, hung up, and spent the next hour taking detailed photographs of my property from every possible angle. The propane tanks were completely hidden behind the lattice screen. You could not see them from the street, from the sidewalk, or from any neighboring property unless you physically walked into my side yard and looked behind the screen. I documented everything with timestamps and multiple shots. By the time I finished, my phone rang. It was Marcus again. "Okay." I looked at the covenant section she cited. It does mention flammable materials, but there's a clause that allows for propane tanks up to 40 pounds if they are properly screened and not visible from common areas or public streets. Your tanks are 20 pounds each, and they are screened. She has no case. So I can fight this. You can, but here's the thing. Fighting an HOA is expensive and time-consuming. Even when you are right, they can drag it out, rack up legal fees, and make your life miserable. I have seen people spend $10,000 in legal fees over $500 fines. That's insane. That's HOAs. My advice: request a formal hearing with the board. It's free and you can present your evidence. If they rule against you anyway, then we can talk about legal action. But document everything. Every interaction, every email, every phone call. These things have a way of escalating. I thanked Marcus and immediately drafted an email to the HOA board requesting a formal hearing to contest the violation. I attached my photographs and cited the exact covenant language that allowed my propane tank setup. I kept my tone professional and factual, even though what I really wanted to do was tell Deborah exactly where she could stick her violation notice. The response came 3 hours later. The hearing was scheduled for the following Tuesday evening at 7 o'clock at the community center. The email was signed by Deborah Patterson, HOA president, and her tone dripped with condescension. We look forward to reviewing your concerns, though we must note that the board's decision on code violations is final and binding per the community covenants. That last line stuck with me. Final and binding. Even if I presented irrefutable evidence that I was in compliance, they could still rule against me just because they felt like it. The system was rigged from the start. I spent the next 3 days preparing for the hearing like I was arguing before the Supreme Court. I printed out photographs, highlighted relevant sections of the covenants, and even prepared a short presentation on my laptop. I talked to my neighbors on both sides, the Chens and the Rodriguez family, and got written statements from both confirming that they could not see my propane tanks from their properties and had no issues with them. Tuesday evening arrived, and I walked into the community center conference room feeling prepared but wary. Deborah sat at the head of a long table with 2 other board members I recognized from neighborhood gatherings. On her left was Patricia Winters, a woman in her 60s who always wore too much perfume and complained about kids riding bikes too loudly. On her right was Frank Morrison, a retired accountant who I had always thought was reasonable until I saw him sitting there with the same pinched expression as the 2 women. "Mr. Lawson, please have a seat," Deborah said, gesturing to a single chair facing the table like I was being interrogated. She was wearing a cream-colored blazer and had her blonde hair pulled back so tight it looked painful. Her makeup was perfect, her nails were manicured, and she had this air of absolute authority that she clearly relished. I sat down and placed my folder of evidence on the table. "Thank you for seeing me. I believe there has been a misunderstanding regarding the violation notice I received." "There is no misunderstanding, Mr. Lawson," Patricia chimed in, not even looking at me. She was reading from a tablet in front of her. "You are storing flammable materials on your property in violation of Section 12.4. With respect, Section 12.4 includes an exception for properly screened propane tanks up to 40 pounds. My tanks are 20 pounds each and are screened behind an HOA-approved lattice structure. I have photographs showing they are not visible from any public area or neighboring property." I slid my folder across the table. Deborah opened it, glanced at the first photograph for maybe 2 seconds, and closed it again. "Mr. Lawson, the board has determined that your screening is inadequate. The tanks are potentially visible during certain times of day when the sun creates shadows and silhouettes. That's not what the covenant says. It says not visible, and they are not visible. Shadows and silhouettes are not the same as visible objects." Frank finally spoke up, his voice flat and bureaucratic. The board has discretionary authority to interpret covenant language. We have determined that your installation does not meet community standards. The fine stands. You have 72 hours from the original notice, which means you have approximately 48 hours remaining to remove the tanks or relocate them to a compliant location. And where exactly would a compliant location be? Inside your garage, Deborah said, folding her hands on the table. That's where flammable materials should be stored. So you want me to store propane tanks inside my garage where they would be in an enclosed space instead of outside in an open, ventilated area. That's actually more dangerous. That's where they need to be to comply with our standards, Mr. Lawson. Fire code allows for proper ventilation systems in garage storage. I could feel my frustration building, but I kept my voice level. I would like to see the specific policy that requires garage storage. That's not in Section 12.4. It's an established interpretation that has been consistently applied, Patricia said, finally looking up from her tablet. We have had several other homeowners store their propane tanks in garages without incident. Then I would like documentation of that established interpretation. When was it adopted? Was it voted on by the community? Because I reviewed all the covenants and amendments before I installed my tanks, and there is nothing about garage storage requirements. Deborah's expression hardened. Mr. Lawson, I understand you are upset, but the board has made its decision. The fine stands. You can either comply or face additional penalties. We can also place a lien on your property if fines remain unpaid. Are you serious? You are going to place a lien on my house over 2 propane tanks that are in complete compliance with the written covenants. We are going to place a lien on your house if you refuse to pay fines for documented violations. That's how enforcement works in a community association. I gathered my folder and stood up. This is not over. I will be consulting with my attorney about your interpretation of the covenants. That's your right, Mr. Lawson, Deborah said, her voice sickeningly sweet. But I should warn you that the association has a legal fund specifically for these matters. We have excellent attorneys on retainer. Fighting us will cost you far more than just moving your tanks. I walked out of that community center shaking with anger. The hearing had been a complete sham. They had no intention of listening to my evidence or considering the actual language of the covenants. This was about power and control, nothing more. When I got home, I called Marcus and told him everything. They can't do that, he said immediately. Their interpretation is not supported by the covenant language you sent me. But Henry, I have to be honest with you. Fighting this could cost you thousands. Even if you win, you will spend more in legal fees than the fine amount. So they just get away with it. They can make up interpretations and threaten liens, and there is nothing I can do. I am not saying that. I am saying you need to pick your battles carefully. Let me draft a formal response citing the covenant language and asking them to reconsider. Sometimes a lawyer's letterhead is enough to make them back down. If that does not work, we can discuss filing a lawsuit, but I want you to understand what you are getting into. That night, I could not sleep. I kept thinking about Deborah's smug face and her threats about liens and legal funds. Around 2 in the morning, I got up and went outside to look at my propane tanks. They sat there innocently behind their lattice screen, just 2 metal cylinders that powered useful appliances. It was insane that they had become the center of this conflict. I walked around to the side of my house and looked at the layout of my property versus my neighbors. That is when I noticed something interesting. My property line extended right up to within 3 feet of the community's natural gas line access box. I had never really paid attention to it before because it was just a small metal box in the ground, but I knew what it was. The whole development used natural gas for heating and hot water, and that access box controlled the feed to several houses on my street, including mine. More importantly, I remembered something from the Planning Commission meetings when this development was first built. I had read through all the documentation when I bought my house. The builder had installed a backup heating system for the community center and the HOA president's house because Deborah had insisted on it during construction. It was some kind of propane-powered backup system in case the natural gas service was interrupted. And if I remembered correctly, the propane tanks for that system were stored on my property easement because that was where the builder had the most space during construction. I went back inside and dug through my property records until I found the plat map and easement documentation. Sure enough, there was an easement along my property line for utility access and maintenance. And according to the notes, there were 2 100-pound propane tanks installed on that easement to power the backup heating system for the community center. The next morning, I went outside with a tape measure and my property documents. I walked along the fence line until I found what I was looking for, a locked enclosure about 4 feet tall, painted the same desert tan as everything else in the neighborhood to blend in. It was technically on the easement, which meant it was not exactly on my property, but it was not exactly community property either. It was in a legal gray area. I took photographs of the enclosure from every angle, then measured its distance from my property line. 6 inches. The propane tanks inside that enclosure were 6 inches from my actual property line, on an easement that ran through my land. And unlike my 20-pound tanks, these were 100-pound tanks, much larger and containing much more flammable material. I called Marcus again. I found something interesting. The HOA has their own propane tanks on an easement that runs through my property. Big ones, 100 pounds each. For what? Backup heat for the community center and apparently for Deborah's house. It was installed during construction. But here is the thing, these tanks are barely screened. You can see them if you walk along the fence line, and they are way bigger than mine. Marcus was quiet for a moment. Are they in violation of the same covenant section they are citing you for? That's the question, is not it? The covenant says no flammable materials visible from public spaces or neighboring properties. These tanks are visible from the walking path that runs behind the properties, and they are definitely not in a garage. Henry, this could be leverage. If they are violating their own rules, you could argue selective enforcement. But you need to be careful how you play this. Do not do anything rash. I am not going to do anything rash. I am just gathering information. But even as I said it, a plan was forming in my mind. If those propane tanks were on an easement through my property, and if they were in violation of the same covenant the HOA was using to fine me, then maybe I had more power in this situation than Deborah realized. I spent the rest of the day researching easement law in Nevada. What I learned was fascinating. An easement gave the holder the right to use the land for a specific purpose, but the underlying property owner still retained certain rights. I could not block access to the easement, but I could potentially challenge whether the current use was consistent with the easement's stated purpose. The easement on my property was designated for utility access and maintenance, which was pretty broad language. But it had been granted to the utility company, not to the HOA. The propane tanks served the community center and Deborah's house, which were technically private use, not utility service for the broader community. On Wednesday morning, I received a follow-up email from Deborah. The fine had increased to $300 because I had not corrected the violation within 72 hours. The email also informed me that if the violation was not corrected within 7 days, they would begin proceedings to place a lien on my property. I forwarded the email to Marcus and then drafted my own response. I kept it short and factual. Dear Miss Patterson and HOA board members, I am writing to inform you that I have identified a similar violation of Section 12.4 on the community property easement adjacent to my land. 2 100-pound propane tanks are stored in minimal screening and are visible from the public walking path. Per the covenant language, these tanks appear to be in violation of the same section you have cited in my case. I am requesting that the board address this violation and provide documentation of any exceptions or interpretations that would allow these tanks while prohibiting my compliant installation. Additionally, I am requesting full documentation of the easement usage for private backup heating systems and whether this use was properly authorized. I look forward to your response. I hit send before I could second-guess myself. Within an hour, my phone rang. It was not Deborah. It was Frank Morrison from the board. Mr. Lawson, I received your email. I think there may be some confusion about the easement tanks. Those are for community use, not private use. The documentation I have shows they provide backup heat for the community center and for the HOA president's residence. The community center I understand, but the president's residence is private property. That was a special arrangement made during construction because the president needs to be able to function during emergencies to coordinate community response. So there are special arrangements for some homeowners but not others. That sounds like selective enforcement, Frank. He sighed, and I could hear the frustration in his voice. Look, Henry, between you and me, I think Deborah is being unreasonable about your tanks. They are fine where they are, but she is the president and Patricia backs her up on everything, so I am outvoted. My advice: just move them into your garage for now, wait a few months and then move them back. She will forget about it. That's not how this should work. The covenants are supposed to apply equally to everyone. In theory, yes. In practice, the president has a lot of discretion. I am just trying to help you avoid a bigger headache. I appreciate that, Frank, but I am not going to move my tanks. They are in compliance with the written covenants. If the board wants to fine me, they will have to explain why the HOA's own tanks are acceptable while mine are not. After I hung up, I felt a small surge of satisfaction. I had put them on the defensive, but I also knew this was just beginning. Deborah was not going to back down easily. That evening, I got a phone call from an unknown number. When I answered, a woman's voice I did not recognize said, "Mr. Lawson, this is Christine Ford from Ford and Associates. I am the attorney representing the Meadowbrook Estates, HOA. I understand there is a dispute regarding a covenant violation on your property." "That's correct. I have reviewed the matter, and I have to inform you that the board's interpretation of the covenants is within their authority. The fine is valid, and if not paid along with correction of the violation, the association will proceed with lien proceedings. Even though the HOA itself has similar tanks that violate the same covenant." There was a pause. "I am not aware of any HOA violations. The tanks you are referring to are on an easement and serve a community purpose. They are not comparable to your situation. They are 100-pound propane tanks, 5 times larger than mine, with minimal screening, visible from public areas. The covenant makes no distinction between private and community use. It says no flammable materials visible from public spaces, period. Mr. Lawson, if you intend to continue disputing this matter, I suggest you retain your own counsel. The association has given you multiple opportunities to comply. We will not continue to debate this informally." She hung up before I could respond. I immediately called Marcus and told him about the conversation. "Okay, now we are into attorney territory," he said. "I can represent you, but I need you to understand the costs. I will need a $5,000 retainer to start, and this could go beyond that depending on how far they want to push it." $5,000 for propane tanks? No, for fighting an HOA with unlimited legal resources who does not want to admit they are wrong. This is not about the tanks anymore, Henry. This is about them maintaining their authority. They will spend $20,000 to win a $500 fine just to prove a point. I sat down heavily on my couch. This is insane. It is. That's why most people just comply, even when they are right. The system is designed to make fighting back too expensive. But if you want to do this, I am with you. I think you have a solid case, especially with the selective enforcement angle, but you need to decide if it is worth it. I thought about Deborah's face during that hearing, her casual threat about liens, her absolute certainty that she could do whatever she wanted. I thought about all the other homeowners she had probably pushed around over the years, people who just gave in because fighting was too hard. "Let us do it," I said. "Draft whatever you need to draft. I want to fight this." "Okay, I will send you a retainer agreement, and Henry, document everything. I mean everything. Every interaction, every phone call, every time you see her or any board member. This is going to get uglier before it gets better." He was right about that. The next morning, I woke up to find another violation notice on my door. This one was for unapproved modification to property screening structures. Apparently, the lattice screen I had built to hide my propane tanks was not properly approved, even though I had submitted plans for it 2 years ago and received written approval from the Architectural Review Committee. I still had the approval letter in my files. I took a picture of the new notice and sent it to Marcus along with the original approval letter. He called me back within minutes. "They are escalating. This is harassment at this point. They approved your screen, you built it to specification, and now they are claiming it is not approved. We need to respond formally. I am drafting a cease and desist letter right now." By noon, Marcus had sent a formal letter to the HOA's attorney outlining the issues. My propane tanks were in compliance with the written covenants. The screening had been properly approved. The HOA's own tanks appeared to violate the same rules they were enforcing against me, and the multiple violation notices constituted harassment and selective enforcement. The response came 2 days later. The HOA was offering to waive the fines if I moved my tanks into my garage within 30 days. It was framed as a generous compromise, but it was really just a way for them to avoid admitting they were wrong. What do you think? I asked Marcus when he called to discuss the offer. "I think it is an admission that they know they are on weak legal ground. They want you to comply so they do not have to defend their interpretation in court. But it is your call. You could take the offer, move your tanks, and be done with it. And let them keep doing this to other people. No, I want to push forward. Then we file a lawsuit. We will ask for a declaratory judgment that your tanks are in compliance, an injunction against the HOA from enforcing the fines, and damages for harassment and selective enforcement. It is going to take time, and it is going to cost money. File it." The lawsuit was filed the following Monday. I was suing the Meadowbrook Estates Homeowners Association and Deborah Patterson individually for exceeding her authority as president. Marcus explained that going after her personally would put pressure on her to settle because her own assets could potentially be at risk if we proved she acted in bad faith. The morning after the lawsuit was filed, I went outside to check my mail and found Deborah standing in my driveway. She was wearing workout clothes and holding her phone like she was in the middle of a conversation, but I was pretty sure she had been waiting for me. "Good morning, Henry," she said, her voice dripping with false sweetness. "I wanted to talk to you neighbor to neighbor, off the record." I do not think that is a good idea, Deborah. Our attorney should handle communication from here on out. Oh, come on. We are neighbors. We should be able to work this out without all the legal drama. You are making this so much harder than it needs to be. I am making this hard. You are the one who fined me for tanks that are in compliance with your own rules. She stepped closer, and I could see the anger behind her fake smile. Those rules are there for a reason, Henry. We are trying to maintain property values and community standards. When someone like you decides the rules do not apply to them, it affects everyone. The rules do apply to me. I followed them exactly. You are the one making up new interpretations that are not in the written covenants. I am the president of this association, and I have the authority to interpret those covenants. If you do not like it, you can run for the board yourself next election. But until then, you need to respect the board's decisions. Is that why you are being sued? Because you respected the covenant language. Her expression hardened, the fake smile disappearing completely. You are making a big mistake, Henry. This neighborhood is not going to be comfortable for you going forward. People do not like troublemakers. Are you threatening me? I am informing you of reality. When you sue the HOA, you sue the entire community. People are going to take sides, and I do not think you are going to like which side most of them choose. She walked away before I could respond, and I stood there feeling my heart pound. I immediately went inside and wrote down everything she had said word for word while it was still fresh in my mind. Then I called Marcus. She confronted you directly after we filed suit. That is incredibly stupid of her. Did anyone else see it? I do not think so. It was early morning. Okay, write down everything she said exactly as you remember it. This is evidence of intimidation and retaliation. If she is dumb enough to do this in person, she might be dumb enough to do it in writing too. Save every email, every text, everything. Over the next 2 weeks, things escalated in weird, petty ways. My trash cans were knocked over 3 times, always on the nights before collection. Someone let the air out of my car tires twice. I received another violation notice for lawn maintenance issues, even though my lawn was in perfect condition. When I went to the community pool, conversations would stop as soon as I approached. Frank Morrison caught me in the parking lot of the grocery store and told me quietly that Patricia and Deborah were organizing other homeowners to ostracize me. They were telling people I was costing the association money with my lawsuit, and that everyone's fees might have to go up to cover the legal costs. It was a deliberate campaign to turn the neighborhood against me, but not everyone was on board with Deborah's program. My neighbors, the Chen family, made a point to come over and tell me they supported me. Michael Rodriguez, who lived on the other side, said he had dealt with Deborah's arbitrary enforcement before and was glad someone was finally standing up to her. She tried to fine me for parking my work truck in my driveway, he told me. Said it was commercial vehicle and not allowed, even though the covenants only restrict vehicles over certain weight limits. My truck is just a regular pickup with my landscaping company logo on it. I ended up parking it at my sister's place just to avoid the hassle, but it pissed me off. Why did not you fight it? He shrugged. Single father with 3 kids. I did not have time or money for a legal battle. It was easier to just give in. But what she is doing to you is wrong, man. Those propane tanks are fine. I appreciated the support, but I also understood why people like Michael did not fight back. The system was designed to make compliance easier than resistance, no matter how wrong the enforcement was. The discovery phase of the lawsuit began, and Marcus requested documents from the HOA. All correspondence regarding my violation, all documentation of the easement propane tanks, all records of covenant interpretation and enforcement for the past 5 years, and financial records showing how the legal budget was allocated. The HOA's attorney fought every request, claiming most of it was irrelevant or overly broad. The judge ordered them to produce at least some of what we asked for, including the enforcement records. That was when things got interesting. Marcus called me one evening, excitement clear in his voice. "Henry, you are not going to believe what I found in the enforcement records. Over the past 5 years, the HOA has issued 147 violation notices. Guess how many of those were appealed or resulted in fines being waived? I do not know. 20. 73. More than half. And guess who decides which violations get waived and which ones get enforced to the maximum? Deborah Patterson has personal discretion over fine waivers under a policy the board adopted 3 years ago. She has been selectively enforcing rules based on whether she likes the homeowner or not. Can we use that? Absolutely. It shows a pattern of arbitrary enforcement. Even better, I found 3 other cases where homeowners had propane tanks. One was told to move them to the garage like you were. One was never cited at all, even though the tanks were clearly visible. And one was initially cited but had the fine waived after Deborah's attorney husband handled some legal work for the association. We can argue that enforcement is completely arbitrary and based on her personal preferences. The case was starting to look stronger, but the process was grinding slowly forward. We had a preliminary hearing scheduled in March, which was still 2 months away. In the meantime, I was still living under the threat of fines and liens. Then, one cold morning in late January, something happened that changed everything. Nevada was hit with an unusual winter storm that brought temperatures down into the teens. The natural gas company sent out an alert that they were experiencing service issues due to the extreme cold causing line freezes and pressure problems. Service might be interrupted intermittently for several days. Sure enough, my heat cut out around noon that day. I called the gas company, and they said they were working on it but had dozens of outages in the area. In the meantime, I should use alternative heating if available. I had a fireplace, so I was fine. But it got me thinking about the community center and about Deborah's house. They were both on the same gas line that was having issues. And if the gas was out, that backup propane system should kick in automatically. That backup propane system that was powered by tanks on the easement through my property. I bundled up and walked down to look at the propane enclosure. Sure enough, I could hear the faint sound of a generator running inside. The backup system had activated. Those 100-pound tanks were currently providing heat to the community center and to Deborah's house, while most of the neighborhood was dealing with cold houses and disrupted service. I went back home and pulled out all my property documents again, reading through the easement agreement carefully. The language was specific. The easement was granted for utility access and maintenance. It said nothing about private backup heating systems. The easement ran to the utility company, not to the HOA or to individual homeowners. I called Marcus. The backup propane system just kicked in because of the gas outage. Those tanks on my property easement are currently heating the community center and Deborah's house while everyone else is cold. I think the easement is being used improperly. What do you mean improperly? The easement was granted for utility access, not for private backup systems. The HOA is using my property to provide preferential service to the president's house. That cannot be legal. Marcus was quiet for a long moment. Let me research this. If you are right, you might be able to challenge the easement usage. But Henry, be very careful here. Do not touch those tanks or interfere with the system in any way. That could backfire badly. I am not going to touch anything. I am just saying the easement might be invalid for this use. Let me make some calls." The next day, the gas service was still out, and the temperature had dropped even further. Most of my neighbors were bundled up in layers, using fireplaces or space heaters to stay warm. But lights were on at the community center, and when I walked past Deborah's house, I could see she was perfectly comfortable, wearing a light sweater and standing by her window with her coffee mug again. Marcus called me back that afternoon with news. "Okay, I talked to a property attorney who specializes in easements. Your instinct was right. The easement on your property was granted to the utility company for infrastructure access and maintenance. Private backup heating systems are not covered under that easement. The HOA would need a separate easement agreement with you personally to maintain propane tanks for private use. So those tanks should not be there. Not without your permission and a proper easement agreement. The original builder probably installed them without thinking about the legal implications, and it has just continued ever since. But you, as the property owner, have the right to challenge that use. What can I do? You can demand they remove the tanks from your property. Or you can negotiate a formal easement agreement with compensation. Or you can let it continue and use it as leverage in your current lawsuit. That is probably the smartest play because it shows clear hypocrisy. They are violating your property rights while claiming you are violating community covenants. I thought about it carefully. Deborah was warm and comfortable while most of the neighborhood was struggling. She was using my property to maintain her own comfort without my permission. And she had the audacity to fine me for 20-pound tanks that were properly screened and in full compliance with the rules. "I want them removed," I said. "Henry, think about this. If you force removal during a winter storm, you are going to look like the bad guy. People will say you are being vindictive. They are already saying I am being vindictive for defending my rights. At least this way, Deborah does not get special treatment while she is making everyone else's life miserable. She can deal with the gas outage like the rest of us." Okay. "I will draft a formal demand letter, but you need to be prepared for the fallout. This is going to make you very unpopular with certain people." I do not care anymore. She threatened me in my own driveway. She has been harassing me for months. She is using my property without permission. If she wants to play hardball, let us play hardball. The demand letter was delivered the next morning by certified mail. It informed the HOA that I was revoking any informal permission for the propane tanks on my property easement, that the easement did not legally allow for this use, and that the tanks needed to be removed within 72 hours, or I would pursue legal action for trespassing and unauthorized use of my property. I sent a copy to the utility company as well, informing them that the easement on my property was being used for purposes not specified in the original grant, and that I was demanding compliance with the easement terms. The response was swift and furious. Within 3 hours, Christine Ford, the HOA attorney, called me directly. "Mr. Lawson, what exactly do you think you are accomplishing with this stunt? Those tanks provide heat to community facilities. You are putting people at risk during a winter storm. The community center can use the same emergency measures everyone else is using. Space heaters, fireplaces, bundling up. The tanks are on my property without a valid easement, and I want them removed. The easement was established during construction. It is valid. The easement was for utility access, not private heating systems. I have consulted with a property attorney, and my rights are clear. If the HOA wants to maintain those tanks on my property, they can negotiate a proper easement agreement with appropriate compensation. Until then, they are trespassing. This is outrageous. You are clearly retaliating because of the lawsuit. I am enforcing my property rights, the same way the HOA claims to enforce community standards. If you do not remove the tanks within 72 hours, I will have them removed myself and bill the association for the cost." She hung up without another word. I honestly did not know if I was doing the right thing, but I was tired of being pushed around. Deborah had made this personal, and now she was going to face the consequences of her own tactics. That evening, Frank Morrison called me. "Henry, please reconsider this. People are going to freeze. The community center is being used as a warming station for elderly residents who do not have fireplaces." Then the HOA should have thought about that before they decided to harass me over compliant propane tanks. Those 100-pound tanks violate the same covenant I am being fined for. Either the rule applies to everyone, or it applies to no one. This is not about the rule anymore. This is about people's safety. No, Frank, this is exactly about the rule. Deborah has been selectively enforcing covenants based on her personal preferences. She has been using my property without permission for her own benefit, and she threatened me personally for daring to stand up to her. I am done playing nice. You are making a mistake. The whole neighborhood is going to turn against you for this. They already have, Frank. At Deborah's encouragement, at least now she will understand that actions have consequences. After I hung up, I felt a twist of guilt. Frank was right that people were using the community center for warmth. But I also knew that the gas company was working around the clock to restore service, and the storm was supposed to break in the next day or two. The situation was temporary, and there were alternatives. This was not about leaving people in the cold. This was about establishing that Deborah could not have it both ways. The next morning, a truck arrived from a commercial propane service company. They spent about an hour disconnecting the backup heating system and loading the two 100-pound tanks onto their truck. A small crowd of neighbors gathered to watch, and I could hear the muttering even from inside my house. Deborah stood on her front porch, arms crossed, glaring at me across the street. When the truck pulled away, she walked across the street and up my driveway. I met her at the door before she could knock. "You are going to regret this," she said, her voice shaking with rage. "What you just did is despicable. We had elderly people relying on that heat. They can rely on the same alternatives everyone else is using. Or you can open your own house to them since you are so concerned. Your house is one of the properties that backup system served, is not it, Deborah? So you are not just concerned about the elderly. You are concerned about your own comfort. That system was there when I bought the house. It is part of the infrastructure. It is on my property without a valid easement, just like my propane tanks are on my property with valid screening. The difference is I followed the rules and you did not. The board is going to hear about this. You are going to be fined for interference with community systems. Go ahead. Add it to the lawsuit. I am sure the judge will be very interested to hear how the HOA was trespassing on my property while simultaneously fining me for compliant use of my own land." She opened her mouth to say something else, then closed it and walked away. I watched her go back to her house, and for the first time since this whole thing started, I felt like I had some power in the situation. The gas service was restored that afternoon. The timing was almost too perfect. The storm broke, temperatures started climbing back toward normal, and the whole crisis passed within 48 hours of my removing the propane tanks. Some people said I had impeccable timing. Others said I was just lucky that I had not caused a real catastrophe. The lawsuit moved forward. Our preliminary hearing was scheduled for mid-March, and Marcus was confident we had a strong case. The discovery documents showing selective enforcement, the evidence that my tanks were compliant with the written covenants, The proof that the HOA's own tanks violated the same rules they were enforcing against me. And now the revelation that they had been trespassing on my property for years, all added up to a compelling argument. 2 weeks before the hearing, I received an email from a homeowner I barely knew, a woman named Sarah who lived on the other side of the development. She had heard about my lawsuit and wanted to share her own experience with Deborah and the HOA board. "I was fined $1,500 last year for repainting my garage door the wrong shade of tan," she wrote. "I had the color matched to the approved palette at the hardware store, but Deborah said it was 2 shades too light. I could not afford to fight it, so I repainted the door and paid the fine. But then I noticed that Patricia Winter's house has shutters that are not on the approved list at all, and she has never been cited. The whole system is rigged to protect board members and their friends while punishing everyone else." I forwarded Sarah's email to Marcus and asked if she could provide a statement for our case. She agreed, and Marcus added her testimony to our evidence of selective enforcement. More people started reaching out after that. Apparently, my fight with the HOA had become common knowledge in the neighborhood, and people who had been quietly frustrated with the board's behavior for years were finally speaking up. Marcus collected statements from 7 different homeowners, all describing instances of arbitrary enforcement, selective rule application, or disproportionate fines. The HOA's attorney made one final settlement offer a week before the hearing. They would drop all fines and violations against me, acknowledge that my propane tanks were in compliance, and pay $5,000 toward my legal fees. In exchange, I would drop the lawsuit and the claim that they had trespassed with the backup heating system tanks. "What do you think?" Marcus asked. "What about the other homeowners? What about Sarah and everyone else who got screwed by Deborah's selective enforcement? This settlement would only cover you. They are not offering any reforms to the enforcement system or any relief for other homeowners." "Then no. If we take this settlement, Deborah just goes right back to doing what she has been doing. The whole point of this lawsuit was to establish that she cannot make up rules as she goes along." "Okay. Then we go to the hearing. But Henry, there is always a chance we lose. Judges can be unpredictable, and HOAs do have a lot of legal authority. If we lose, you could be responsible for their legal fees on top of your own. That could be $20,000 or $30,000. "I understand. Let us go forward." The preliminary hearing was held on March 15th in the Clark County District Court in Las Vegas. Marcus and I arrived early, and I was surprised by how many people showed up. The Chen family was there to support me. Michael Rodriguez came with his brother. Sarah and 2 other homeowners who had provided statements were in the gallery. On the other side of the courtroom, Deborah sat with Patricia Winters and the HOA's attorney, Christine Ford. Judge Raymond Carter presided. He was in his early 60s, with gray hair and a no-nonsense demeanor. He started by reviewing the basic facts of the case, then asked Christine Ford to present the HOA's position. She stood and launched into a prepared argument about the authority of homeowners associations to interpret and enforce covenants, the importance of maintaining community standards, and the reasonableness of the HOA's requirement that I move my propane tanks to my garage. "Your Honor, Mr. Lawson purchased property in Meadowbrook Estates, knowing that he was agreeing to abide by the community covenants. Those covenants give the board discretion to interpret rules and enforce standards. Mr. Lawson's refusal to comply with a reasonable board decision is disruptive to the community and undermines the entire HOA system." Judge Carter listened without expression, then turned to Marcus. "Counsel." Marcus stood and walked to the podium. "Your Honor, This case is not about whether HOAs have enforcement authority. It is about whether that authority has limits. Mr. Lawson's propane tanks are in full compliance with the written language of Section 12.4 of the Community Covenants. They are properly screened, under the weight limit, and not visible from public areas. The HOA's attempt to require garage storage is not supported by the covenant language and is being applied selectively. We have evidence that other homeowners with similar setups have not been cited, and that the HOA itself maintained much larger propane tanks in violation of the same rule until Mr. Lawson forced their removal. "Are you arguing that the board has no interpretive authority?" Judge Carter asked. "No, Your Honor. We are arguing that interpretive authority must be exercised reasonably and consistently. When a board member threatens a homeowner personally, when enforcement is clearly selective based on personal preferences, and when the board violates its own rules, that is not reasonable interpretation. That is arbitrary abuse of power." The hearing continued for another hour, with both sides presenting arguments and evidence. Judge Carter asked pointed questions of both attorneys, particularly pressing Christine Ford on the selective enforcement issue and the easement trespass claim. Finally, he announced that he would issue a written ruling within 2 weeks. We left the courthouse uncertain of how it would go, but feeling like we had presented our case well. The 2 weeks waiting for the ruling were tense. Deborah ignored me completely, not even looking in my direction when we happened to be outside at the same time. The violation notices stopped, which Marcus said was a good sign. If the HOA was backing off enforcement, they probably knew their position was weak. The ruling came down on March 30th. Judge Carter found in my favor on almost every point. He ruled that my propane tanks were in compliance with the plain language of the covenants, that the HOA's attempt to require garage storage was not supported by the written rules, that the enforcement against me was arbitrary and selective, and that the fines were invalid. He ordered the HOA to cease all enforcement action regarding my propane tanks and to pay $15,000 toward my legal fees. On the easement issue, he ruled that the HOA had indeed been using my property beyond the scope of the original easement, and that they owed me compensation for past use. He ordered a separate proceeding to determine the amount of compensation, but he made it clear that property owners have rights that HOAs must respect. Most importantly, he issued an injunction requiring the Meadowbrook Estates HOA to adopt clear, written standards for covenant interpretation and enforcement, and to apply those standards consistently to all homeowners. The board could no longer make up interpretations on the fly based on personal preferences. I was ecstatic. Marcus was thrilled. We had won on every major issue. The legal fees award would not cover everything I had spent, but it would cover most of it. And the precedent was exactly what we had hoped for, a clear statement that HOAs must follow their own rules and cannot enforce them arbitrarily. The reaction in the neighborhood was mixed. Some people congratulated me and thanked me for standing up to the board. Others muttered about troublemakers and lawsuits, but the overall mood seemed to shift. Deborah had lost her aura of untouchable authority. She was just another homeowner now, subject to the same rules as everyone else. 3 weeks after the ruling, there was an emergency HOA board meeting. Frank Morrison called to give me a heads up. Deborah and Patricia are being removed from the board. There has been a petition signed by over 60% of the homeowners demanding their resignation. After your lawsuit, other people started filing complaints about their enforcement practices. The board is trying to clean house before there are more lawsuits. What about you, Frank? Are you staying on? I am staying for now, but we are having new elections next month. The whole thing is being restructured. Your lawsuit really changed everything, Henry. People were not happy with how things were being run, but nobody wanted to be the first to speak up. You did that, and now everyone else feels empowered. The board elections happened in May. Deborah did not run for re-election. Patricia did run, but lost badly to a younger homeowner named Jake, who campaigned on transparency and fair enforcement. Frank was re-elected, and 2 other new members joined the board with similar reform-minded platforms. The new board's first action was to rescind dozens of questionable fines and violations that had been issued over the past 2 years. They established clear, written guidelines for enforcement that tracked the actual covenant language rather than board members' personal preferences. They created an appeal process that was actually fair rather than the sham hearing I had experienced, and they formally apologized to me for the harassment I had endured. Sarah, the woman who had been fined for her garage door color, got her $1,500 back. Michael Rodriguez was told he could park his work truck in his driveway as long as it met the weight restrictions in the covenants. Several other homeowners received refunds or fine waivers. The separate proceeding on easement compensation took a few more months, but eventually, the HOA agreed to pay me $25,000 for their unauthorized use of my property over the years. They also granted me a lifetime waiver on HOA fees in exchange for a formal easement agreement if they ever wanted to reinstall a backup heating system, which they never did. As for Deborah, she kept a low profile for a while. Then, in August, I saw a for sale sign go up in front of her house. Frank told me she was moving to Arizona to be closer to her daughter. I suspected the real reason was that she could not stand living in a neighborhood where she no longer had power over everyone. The house sold in September, and a nice young couple with 2 kids moved in. They introduced themselves to all the neighbors, including me, and seemed genuinely friendly. When I told them about the propane tank saga, they laughed and said they had moved from a neighborhood with an even worse HOA. "That's why we did so much research before buying here," the husband said. "We heard about your lawsuit and the board reforms. It actually made us more interested in the neighborhood. We wanted somewhere with an HOA that actually follows its own rules. My propane tanks are still behind their lattice screen, right where they have always been. Nobody has complained about them since Judge Carter's ruling. I installed a 3rd tank last month for a new patio heater, and the current board approved it without any issues. The whole experience taught me a lot about power, principle, and the importance of standing up for yourself even when it is expensive and difficult. I spent about $8,000 after the legal fee award to fight a $250 fine. By any rational calculation, that was a terrible financial decision. But it was not really about the money. It was about refusing to be bullied and establishing that rules have to mean something. Marcus told me that my case has been cited in 3 other HOA disputes in Nevada as precedent for limiting board authority and requiring consistent enforcement. That makes me feel like the fight was worth it. Maybe Deborah will think twice before abusing her authority in Arizona. Or maybe she will find a new neighborhood to terrorize. Either way, it is not my problem anymore. I still live in Meadowbrook Estates. My lawn is still trimmed to exactly 2.5 inches. My house is still painted in approved colors. I follow the rules because that is part of living in a planned community. But now the rules are actually written down and applied fairly, which makes all the difference. Last week, I was grilling on my back patio using one of my supposedly prohibited propane tanks when Frank Morrison walked by on his evening walk. He waved and called out, "Smells good, Henry. You should invite the new board over for dinner sometime. Show them how reasonable homeowners can work together with reasonable board members. I told him I would think about it. And I will. Because that is what community is supposed to be about. People working together, following fair rules and treating each other with respect. Not one person with a little bit of power using it to make everyone else miserable. My propane tanks sit behind their screen, functioning exactly as they should, heating my grill and powering my backup generator. They are in the same spot they have always been, in full compliance with the covenants, visible to nobody unless they walk onto my property and look behind the screen. Deborah's house has new owners who have never sent me a violation notice. The community center has a new heating system that does not require tanks on anyone's private property. And the Meadowbrook Estates, HOA, has new leadership that understands the difference between maintaining standards and abusing authority. Sometimes you have to fight back, even when it is expensive and stressful and everyone tells you to just give in. Sometimes the principle matters more than the practical outcome. And sometimes, if you are lucky and persistent, you actually win. That is my story about how the HOA fined me for storing propane tanks in compliance with their own rules. How I moved their backup heating tanks off my property in the middle of a winter storm. And how the whole thing ended with a corrupt board being removed and real reforms being implemented. It was not easy, and there were times I questioned whether it was worth the stress and expense. But looking back now, sitting on my patio with my grill running on perfectly legal propane, I know I made the right choice. The neighborhood is better for it. The rules are fairer. And Deborah Patterson learned that threatening people in their own driveways and selectively enforcing covenants based on personal vendettas has consequences. Maybe not immediate consequences, but consequences nonetheless. That is good enough for me.